This sermon had its genesis at the social justice auction last spring when Nancy Carrillo was the highest bidder for the item, the right to name a sermon topic. And this was her choice. So thanks, Nancy. She was here a minute ago. Where is she? There she is back there. Thank you. As I began my research into this topic, I soon ran into a quagmire of legal terms and recruited our fellow member, Peter Chestnut, to help me out. Peter is a lawyer who represents Pueblo Indian governments and entities. His law practice emphasizes Indian affairs and water law. So thank you, Peter. Natural rights. So natural rights are the kind of rights that we sometimes call human rights, which we accord to a person not because she's a good person or a useful person, but just because she's a person. The sort of rights which Thomas Jefferson called self-evident and unalienable, the rights of life, liberty, and the pursuit of happiness, for instance. Natural rights can be enshrined in law specifically, and they should be considered in the creation of legal codes, but they transcend the law. The law of a nation could permit one person to own another person, for instance, but most of us would consider that law to be in the wrong, a violation of natural rights. Most of us would believe that the law was transcended by the natural rights of human beings to independent agency. One problem with natural rights is that they don't exist anywhere except in the human heart and mind. They're not written in the stars. And they only exist when human hearts they exist in are in a powerful majority, and only then is there much practical use to the idea of natural rights. There were enough powerful people who thought it's self-evident that men have a right to life, liberty, and the pursuit of happiness in 1776 to start a war with England, but not enough believed it to avoid a civil war less than a century later, and not enough believed it to be self-evident even to most women that they should be included in this calculus for yet another generation. The proponents of natural rights for nature might say that a tree has a right to life akin to a person's right to life, and a mountain has a right to maintain its mountainness and not be mined to oblivion, or that the species tiger has a right to remain a viable species and not to be driven to extinction by human activity. Now, I like it when trees, especially big, old, beautiful, rare trees like redwoods, stay alive. And I don't like driving by that mountain in the Jemez, which is being ground down into flatlands so that we can have stonewashed jeans, which I think are very silly. And I want, with all my heart, for the tiger to remain a healthy, viable species in the wild. But I have to oppose the notion that these entities have natural rights for both practical and philosophical reasons. I don't have any way of knowing God's plan for the tiger, or what the trajectory of evolution would be for the tiger if humanity had not taken over the planet. So it's hard to know what that tiger's natural rights would actually be. And if the tiger has a right to remain a viable wild species, why not the silvery minnow? Why not the Ebola virus? Just because it's prettier? That's bad philosophy. If I must respect the life of the redwood tree because it has a right to be the way it is, I then have to respect that miserable mimosa, an invasive weed tree if there ever was one, which drops more trash on my yard than a ticker tape parade. Of course, it's not the mimosa's fault that it was brought here. And if a mountain has an inherent right to remain a mountain, why wouldn't the desert under my house have the right to keep its scrub and chamisa, which are currently prevented by my concrete foundation? We get ourselves really fast into major problems when it comes to thinking that natural objects have natural rights. And to the question, should we recognize the natural rights of nature, I would say we shouldn't. We can't do it in any rational way. Not everyone would agree. There is, for instance, an environmental movement to get nations to ratify a universal declaration of the rights of Mother Nature, Mother Earth. Notice that phrasing. These folks don't aim to give Mother Earth rights. They aim to get us to agree that Mother Earth has rights by nature, which we should recognize, the way we recognize human rights in a companion document, the Universal Declaration of Human Rights. The material with which they back up their request doesn't actually aim at convincing us that Mother Earth is the sort of philosophical entity that nature intended to have rights, but rather aims at convincing us that the common human attitude of owning and pillaging Mother Earth has us teetering on the brink of disaster. And while I don't quarrel with people who think that we are on the brink of disaster and should do something about that, I myself think that this is a bad use of a philosophical tool and a dead end. So originally, I thought this would be a really short sermon. Then I came across a book called Should Trees Have Standing by Christopher Stone. This book is written by a lawyer. He doesn't even consider the possibility that nature should have natural rights, but jumps rather into the possibility that natural objects should have legal rights. The book's about 35 years old, and his ideas have gained traction over time. Stone felt that extending some legal rights, particularly the right to initiate court action, would considerably simplify the problem of protecting the environment. I'm going to let Peter explain to you all of what that means and what he thinks about that and other legal ways of protecting the environment. I'll just comment, while philosophical categories like natural rights are immutable and self-evident, the law changes all the time, and often in ways that challenge our thinking. Once the idea that children should have legal rights would have been unthinkable. In Roman law, the father had the right of life and death over his children. Infanticide was widely practiced. Legal rights were extended to African Americans and women over 2 centuries ago in this country, but that's not that long. In the past few years, we've seen the legal right to marry extended to same-sex couples. This far-reaching change still seems amazing, even to those who sought it, and threatening and preposterous to others. But legal rights change. The idea of extending some legal rights to objects of nature was also seen as threatening and preposterous, perhaps even so preposterous as to be not even worth refuting in prose. An example of that is our reading.
In 1971, the Sierra Club sued the U.S. government for permitting Disney Corporation to develop a large tract of national forest acreage in the Mineral King Valley. The Sierra Club maintained that this development, and all that went with it, would despoil and deface the area and change its ecological balance. The suit was thrown out because the judge maintained that the Sierra Club was not in any real way damaged by this development. That decision was ultimately upheld by the Supreme Court, but by that time, the question had been raised in law review journals about the possibility of legal standing for entities such as a valley. Justice Douglas, in his dissent, spoke approvingly of this possibility. In response, another lawyer, John M. Naff, penned a poem for the Journal of the American Bar Association. If Justice Douglas has his way, oh, come not that dreadful day, we'll be sued by lakes and hills, seeking a redress for ills. Great mountain peaks of name prestigious will suddenly become litigious. Our brooks will babble in the courts, seeking damages for torts. How can I rest beneath a tree if it may soon be suing me? Or enjoy the playful porpoise while it's seeking habeas corpus? Every beast within its paws will clutch an order to show cause. The courts, besieged on every hand, will crowd with suits by chunks of land. Ah, but vengeance will be sweet, since this must be a two-way street. I'll promptly sue my neighbor's tree for shedding all its leaves on me. Soon after the Supreme Court decision, the area was annexed by act of Congress into the Sequoia National Park and has been protected since then.
Good morning. The humorous poem we just heard actually brings our attention to protections the law can provide to natural objects. In the 40 years since the opinion by Justice William O. Douglas, a staunch conservationist on the U.S. Supreme Court, law has changed in ways which give greater recognition to concerns about human impacts on the environment. My time at the podium today will focus on 1, the framework for rights associated with environmental protection, 2, legal standing, 3, duties, and 4, remedies. Law can be a tool to help mitigate or reduce damages to nature. It cannot prevent them entirely. Law is a human creation. It cannot by itself halt the rapid exhaustion of natural resources and environmental impacts of human activity in our time, which arise largely due to unprecedented levels of human population, affluence, and technology on our planet Earth. Law in our federal system arises from 3 kinds of sovereigns: federal, state, and tribal governments, which exercise control over land and water. Courts look to written law to determine what law says. Each federal, state, and tribal government has some authority to make laws and be governed by them. Each is also limited. Governments have waived to some extent their protections against specific kinds of claims which can be heard in courts. Without that waiver, governments can't be sued. Rights are woven together with responsibilities. In our country, law arises in 2 ways: legislation by state, federal, or tribal government, and 2, court decisions to require compensation for injuries caused by another. The second is called common law. Nature itself has no legal rights recognized outside of a statutory framework in our system. There can be a disconnect between human laws and the laws of nature. Rights in our current legal system can be enforced only if Congress or a state legislature or tribal council specifically recognizes and allows legal review of actions that are colorably inconsistent with that right. At common law and in our statutes, natural objects do not hold legal rights. There can be and is tension between some laws. For example, the 1872 mining law was enacted to encourage individual citizens and potential citizens to make a living by mining on public lands. Other federal laws now require federal agencies to study foreseeable impacts to natural and cultural resources before issuing a permit or approving a plan for mining on public lands. Standing in the legal sense is the ability to bring a lawsuit to enforce a claim or right. Injury in fact is a requirement. Traditional view of legal standing in lawsuits affecting the environment generally strikes some balance of economic hardships on human beings. No court has allowed standing for a lawsuit brought only in the name of a natural object or species to go forward. There is a movement in law towards giving people or groups of people concerned about environment the right or standing to seek legal review of actions that may affect nature. Laws passed since the late 19th century and mainly in the mid-second half of the 20th century have recognized rights for citizens to sue the government agencies to make them pay more attention to the environment in carrying out their duties. Since the Sierra Club lawsuit that gave rise to the poem read earlier, Congress has passed the Clean Water Act, the Clean Air Act, the Endangered Species Act, among others, which allows citizens to sue for alleged violations of those laws. One result has been court rulings which prevented construction of a large dam in Tennessee in order to protect an endangered species. Congress has recognized as natural resource trustees state and tribal governments, as well as federal agencies with land management responsibilities. These have authority to recover damages caused by releases of hazardous materials to the environment. The goal is to restore restoration of services provided by natural resources in their jurisdictions. The trust responsibility includes jurisdiction to sue if necessary to restore services lost as a result of natural resource damage. New Mexico has an Office of Natural Resource Trustee. Congress in the past 50 years has enacted numerous laws to protect the environment. They impose duties on federal agencies with the intent to benefit the environment by considering potential effects and alternatives. They can generally be enforced in federal court. Some important ones are the Wilderness Act of 1964, which protects some lands from motor vehicles and other intrusions. The National Environmental Policy Act, NEPA, requires consideration of environment before any federal agency can make or permit irreversible changes. A federal court has ruled that failure to comply with this law is injury in fact, which can be the basis for federal court review of action by a federal agency. Agencies at all levels of government have been created to benefit the environment. For example, we have the New Mexico Environment Department, the Federal Environmental Protection Agency, State of Washington has a Department of Ecology, and there's the U.S. Fish and Wildlife Service. The Fish and Wildlife Service is a federal agency established to act on behalf of threatened and endangered species. The Supreme Court found the Endangered Species Act expressed the plain intent of Congress to halt and reverse the trend towards species extinction, whatever the cost. However, courts have since concluded that the economic feasibility of reasonable and prudent alternatives to a planned action and the feasibility of alternatives on third parties can be factors to consider. Courts will enforce what Congress requires. Judges can differ on what that means. In a 5-4 vote, the U.S. Supreme Court, in a case called United States v. New Mexico, heard an appeal from the New Mexico Supreme Court. The court addressed the nature and extent of water rights for the Gila National Forest. It reviewed an 1897 law. The majority concluded the U.S. intended to reserve only enough water to preserve the timber of the forest and to secure favorable water flows, and did not reserve water rights for aesthetic, recreational, wildlife preservation, or stock watering purposes. Justice Powell dissented, saying, "In my view, the forest consists of the birds, animals, and fish, the wildlife, that inhabit them, as well as the trees, flowers, shrubs, and grasses. I therefore would hold that the U.S. is entitled to so much water as is necessary to sustain the wildlife of the forest, as well as the plants." Mount Taylor, approximately 100 miles to the west of Albuquerque, was nominated as Traditional Cultural Property, a TCP, by 5 Indian tribes to the Registry of Cultural Properties under the New Mexico Cultural Properties Act. The pueblos of Acoma, Laguna, and Zuni, as well as Navajo and Hopi, together asked the State Cultural Properties Review Committee to list approximately 400,000 acres of land above 8,000 feet elevation based on tribal practices over the centuries, which see the mountain as a living landscape. The New Mexico Supreme Court upheld that nomination, despite opposition from many mining companies. This strengthens the requirement for state agencies to consult with tribes before any permits are issued affecting the TCP. Forest Guardians, now Wild Earth Guardians, has filed suit in federal courts in New Mexico based on the Endangered Species Act and the Administrative Procedures Act against federal agencies for not following their duties to protect the silvery minnow in the Rio Grande. The initial suit in the 1990s was brought in the name of the fish, with human beings and organizations as co-plaintiffs. That suit resulted in a cooperative group of government agencies to increase efforts to keep the silvery minnow alive. Those efforts have been significant, but Forest Guardians thinks that's not enough. In July 2014, Wild Earth Guardians, the successor to Forest Guardians, again sued the U.S., alleging that U.S. Bureau of Reclamation and Army Corps of Engineers violated procedural duties by not taking all steps within their discretionary authority necessary to avoid jeopardy to the silvery minnow, resulting in irreversible effects on the minnow and the southwestern willow flycatcher. It asks the court to order additional action by federal water management agencies. Another way for environmental damage to be addressed is by natural resource trustees. The Comprehensive Environmental Response, Compensation, and Liability Act, called CERCLA, recognizes states, tribes, and federal agencies as natural resource trustees for land and water in their jurisdictions. This federal law allows trustees that demonstrate reasonable likelihood of natural resource damages in their jurisdiction to enforce claims against potentially responsible parties. The authorized remedy is money damages for projects that will help restore lost services resulting from damage to natural resources, land, water, flora, and fauna. There is a trustee council for the Los Alamos National Laboratory, LANO. It has as members the state of New Mexico, the pueblos of San Ildefonso, Santa Clara, and Jemez, as well as Department of Energy and Department of Agriculture for the Forest Service. This trustee council is currently working cooperatively to complete a natural resource damage assessment for injury to natural resources resulting from release of hazardous materials from Los Alamos. These trustees can sue the U.S. if necessary to collect money damages caused by release of these hazardous materials into the environment. A natural resource damage assessment plan developed by the trustee council is publicly available. In conclusion, nature will continue in some form. Better for us to ask whether and how humans can and will adjust ourselves, our groups, and our societies in order to weave our lives harmoniously into the interdependent web of life. Law can be a tool to help reduce and minimize harm to that fabric. While the impact of human activity continues to affect the environment, laws can and have been passed and enforced requiring more mindful consideration before irreversible damage occurs. This is a change for the better. However, current human activity, driven by population, affluence, and technology to destroy, are at all-time record levels. Law has evolved to require more attention to the environment, including consideration of potential impacts from corporate and human actions, and remedies for violation of duties imposed by statutory and common law. Ultimately, we need to act in ways that do less with less if we want the human impact on nature to be more respectful and less destructive to nature and the environment. Law can help, but it has its limitations. Thank you.
When I was growing up in the suburbs of Washington, D.C., we sometimes picnicked along the Potomac River, but we were not allowed to go near it. It was so polluted in the 1960s that if you fell in, you had to have a tetanus shot. There were plenty of woods and fields near our home, but the only wildlife I ever saw was common birds like robins who lived in the trees with the squirrels. The only animal more exotic than that I saw in my 13 years there was one sick raccoon. I was in Washington in June, staying with my sister who lives just a few miles from where we grew up. While I was there, we watched people swimming and boating in the Potomac River and spotted in her neighborhood creek bed a fox and an owl. There are so many deer in that urban forest that they regularly cause traffic accidents. Coyotes have returned to the East Coast, and hawks are everywhere, including on the ledges of high-rises where they thrill occupants by building nests and raising young. Last month, my sister looked out her window and saw a black bear. The renaissance of birds is due mostly, it seems, to the banning of DDT. The renaissance of the Potomac River is due to the Clean Water Act of 1972. The resurgence of mammals in suburbia is mostly a matter of the unexpected and often unsung resilience and adaptability of nature, helped along by the changing human heart. I mention all this because sometimes it seems that our human relationship to nature is beyond hope. And when we are beyond hope, we either flail about ineffectively or do nothing. And neither response is faithful to those amazing powers of adaptability and resilience, which are the gifts of life. There is usefulness in many kinds of strategies, from changing the law, to serving as a trustee, to buying a rain barrel, to keeping your car parked. Pick one. Closing